Guys, Lisa Figueroa here, board certified criminal defense attorney in Florida. Back to talk to you about Alicia Andrews. I appreciate everybody watching and all the great questions. So I have a big update that I want to talk to you about, and actually something that I had missed and we hadn't talked about fully was Alicia Andrews' motion for new trial. Now, before we get to that, there's been a lot of great questions. First of all, there is a hearing, a status hearing set for March 10th. So that's the next thing. It's just going to be a status. The new judge has ordered the transcripts of everything that was done previously by the other judge. All the trial testimony, all of that is going to get typed up so that way this judge can review and get up to speed on everything that happened before she got assigned to the case. Now, a few of you had some questions about what does this mean for the co-defendants? Do they keep the same judge or does their judge switch? That's a great question, but no, the change of the judge only applies to Alicia Andrews. All the other co-defendants remain with the original judge, Judge Cisco, who I believe are currently set for trial on April 8th. Now, will it go to trial then? I don't know, but that is pending. The other thing that just got filed was a motion by the state, filed a motion to get some of the evidence that was introduced, like specifically some of the casings and the brass catcher, just projectiles, different things that were introduced in Alicia Andrews' trial that they need now for the co-defendant's trial. And they asked the court to direct the clerk that is holding all this evidence to give it back or allow them to use it for the co-defendant's trial that they currently have scheduled for April 8th is when it's set to begin. So we talked about what could possibly happen now, right? Everything that just got paused was right before sentencing. And we've talked about how much time she could be facing, whether or not she could get more. And now I mentioned in the video when we talked about the next steps, one of the options an attorney always has after the trial is within 10 days to ask for a motion for new trial or a judgment of acquittal notwithstanding the verdict, meaning even though the jury came back with this verdict, we think that the evidence was insufficient or improper for that charge. And Alicia Andrews' attorney actually did file that motion, but we didn't talk about it because it got lost in the shuffle of everything that we were dealing with, the disqualification about the bias with the judge. But just yesterday, and again, another late filing, 11:59 p.m. You gotta love it. The hard work. Alicia Andrews' attorney filed a motion to reconsider the previous pretrial and trial rulings and second amended motion for judgment of acquittal, notwithstanding the verdict, and or motion for a new trial. What does that mean? We'll get into it. So basically, as attorneys, we're able to consolidate a motion. A motion can ask for multiple things in the alternative. So the first thing they're asking is the judge to reconsider some previous pretrial rulings, and we'll get into the specific things that they're asking for. And then they're also asking, again, for the judge to acquit Alicia Andrews, to basically find her not guilty, enter a judgment of acquittal, regardless of the verdict, and that's something they could legally ask for, and the judge might be able to determine should be granted. And then if that doesn't work, they're also just asking for a new trial. Like, let's start over. And this is before the sentencing. And they can do this. And if the judge agrees, they would start all over with a new jury and now a new judge. I compared this motion with the original motion for new trial, and most of it is exactly the same, except a few things were added in this one. So let's go through it. Now, since we have a new judge, they add an introduction, kind of giving the case history. And now, while I normally would kind of recap the case for those of you who may not know about the facts, they actually put it in here in a really good, succinct, clear form. And so I'm just going to go through it. There's nothing important here. Basically, they start off by saying that the second DCA found that Ms. Andrews' motion to disqualify the trial judge was legally sufficient, and Judge Cisco was disqualified from the proceedings, and that allows this court, this new judge, to reconsider everything that the prior judge had ruled on. So they're asking this court, this new court, meaning the new judge, to reconsider each of the previous judge's factual and legal rulings. And they're saying that that includes, and is not limited to, it includes all of their prior motions in limine, their motions for judgment of acquittal, their motions where they ask for special jury instructions, and then all of the rulings on any of the evidentiary objections during the actual trial. The prior rulings, they're saying, may be reconsidered and vacated, which means nullified, removed, or amended, changed by the court. Ms. Andrews requests that the court consider reconsider her motions for judgment of acquittal, vacate the previous denial of those motions, like undo it, and grant her a motion for a judgment of acquittal, which means acquit her, find her not guilty. And they do put a little footnote there saying that Ms. Andrews intends to submit a supplemental briefing on her request for the court to reconsider the motions for judgment of acquittal made during trial. So that means they're going to provide some additional support or grounds later to supplement this, and they're giving the court a heads up. In the alternative, meaning, okay, Judge, if you're not going to do that and just grant her judgment of acquittal, we're asking for a new trial because, and this is page 2, the only remedy for the remaining rulings, that supra means mentioned above, would be to impanel a new jury so that the case can be tried with the correct pretrial and trial ruling. Under the circumstances, Ms. Andrews is due a new trial. At the very least, this court or the appellate court must grant Ms. Andrews a new trial because the disqualified judge committed reversible error by denying Ms. Andrews legally sufficient disqualification motion. The error was not harmless because the judge made several consequential decisions that could have altered the outcome of the trial. And then they say specifically, namely, the previous judge denied Ms. Andrews' motion for special jury instructions, and for that alone, they're saying, and then the others collectively, like as a whole, the previous error can't survive a harmless error analysis. All of that, harmless error, appellate courts like to say whenever there's an error in the court, in a trial or in a proceeding in the lower court, they will oftentimes say, okay, maybe there was an error, but it was harmless. It wasn't a big deal. And that's how they, I don't want to say get away with, but get by with not having to overturn a conviction or set aside a prior judge's ruling because the error, maybe it was an error, but it was harmless. It wasn't a big deal in the grand scheme of things. What they're saying is this was not harmless. This was a big deal. And there's case law that's really clear about what things are considered harmless and what are not. But here, Andrews' attorney is basically saying that the error in this case, not giving the jury these special jury instructions that were requested, was not harmless and is so critical that this case has to be overturned. It has to be reopened. It has to be allowed to be given a new trial. The other thing they're saying is that for the sake of judicial economy, that means like preserving, being aware of the court's time and not wasting the time of the court and the community, and to be efficient. It makes sense that the court grant her new trial rather than sending this up the road for the appeals court, who they claim is going to definitely grant this. So they are confident that this, if it went to the appellate court, if this gets denied, it's going to get overturned. So we'll be back here anyway. So you're just kind of wasting your time by not ruling in our favor now, because they really feel that the law is on their side. Now, they go into the facts here, and they remind everybody, for those of you who don't remember, June 23rd, 2024, the victim in this case, Charles Fulio Jones, he was killed by masked gunmen. Within months, Miss Andrews was arrested for Mr. Jones' murder and then indicted as a principal to 2 criminal acts: first-degree premeditated murder and conspiracy to commit first-degree premeditated murder. Miss Andrews had 4 co-defendants, all men, all arrested and indicted for the same or similar charges. And then they go through the different things that were addressed. Motions in limine. Remember, we've talked about those are motions to limit or keep certain things from coming into evidence in the trial. Prior to the start of trial, the defense moved in limine to preclude, to stop the state from introducing evidence of a years-long Jacksonville gang war, rap music videos, and various uncharged crimes the state sought to introduce. Judge Sisko denied the defense motion and allowed the state to introduce the evidence. The defense also requested that Ms. Andrews be allowed to present evidence about the nature of her abusive relationship with co-defendant Isaiah Chance. The defense proffered that such evidence was relevant to her state of mind, which is always relevant in a first-degree murder case where the state has to prove intent or premeditation. Although the defense made it clear it wasn't introducing this evidence as an affirmative defense, Judge Sisko and the state erroneously and repeatedly framed the defense request to use domestic violence as a way of arguing a duress defense. So basically, they wanted to get in evidence that her state of mind was impacted because of the volatility or the abuse that they allege was occurring between Isaiah Chance and her. And the state and the judge thought, well, you can't use that, or you're trying to use that as a duress, like I did this because I was under pressure. But they've never acknowledged or said an affirmative defense is something like, yes, I did that, but it's because of this. And what they're saying is, we never said that we're admitting that she did it and then these are the reasons why. testified. They're just going to show the state of mind and why she went to Tampa, for example. Initially, Judge Sisko ruled that the evidence was inadmissible, but then Sisko would later change her ruling on the first day of trial, and they'll get into that more below. That's what infra means, below, beneath, but never allowed the defense to fully introduce the extent of the domestic violence exhibited towards Miss Andrews. And we'll talk about that more in a second. So the stories presented at trial, they have this next section. At trial, the state tried to prove that Miss Andrews conspired with the co-defendants to kill Charles Jones. Why? Because Mr. Jones, an alleged gang member, was engaged in an alleged gang war with Miss Andrews' co-defendants, who were allegedly rival gang members or gang associates. Over the years, many children, teenagers, and young adults were killed as a result of this gang war. Astonishingly, the state's witnesses admitted that Miss Andrews wasn't a gang member and she wasn't a gang associate. Neither was Miss Andrews involved in the Jacksonville gang war. According to the state, Miss Andrews' co-defendants wanted Mr. Jones dead for personal vendettas they had with him. However, the state argued that Miss Andrews joined the conspiracy solely because of an undying allegiance to her boyfriend, Isaiah Chant. According to the state, the Jacksonville gang war spilled into Tampa when Miss Andrews traveled from Jacksonville to Tampa with her co-defendants to stalk and kill Mr. Jones, who was present in Tampa to celebrate his birthday. Miss Andrews is allegedly the lookout or a spotter for the group of boys. So the defense was adamant, and they put in here, the defense denied the state's allegations, arguing that Miss Andrews never conspired with the co-defendants to kill Mr. Jones. Miss Andrews didn't know two of her co-defendants. She never had any conversation with them, much less an opportunity to develop a murder plot. The only co-defendant Miss Andrews had a relationship with and any communication with was her boyfriend, her then boyfriend, Mr. Chant. When she discovered that Mr. Chant was leaving to Jacksonville to go to Tampa, she wanted to go with him. She knew nothing about the murder plot. This is all what they're laying out when she decided to make the trip. She merely believed she was, and this is not just what they're laying out, this was the evidence that came in and also what they intended to produce. Miss Andrews knew nothing about the murder plot when she decided to make the trip. She merely believed that she was going out of town to spend some time with Mr. Chance. Mr. Chance and the other co-defendants arrived in Tampa, left Miss Andrews at an Airbnb for hours, and went to look for Mr. Jones. At first, the group of boys were unsuccessful, but they continued their efforts and eventually were able to locate and gun down Mr. Jones. Miss Andrews provided no identifiable assistance. Again, this is their position, that she didn't help them in any way. Nothing that the state or anyone could identify as her actually assisting in that murder. Several times throughout the night, Mr. Chance, they argue, manipulated Miss Andrews and used her phone to conceal his whereabouts. Miss Jones didn't know about the conspiracy, and so she lacked the requisite intent, meaning the required intent for one of the elements to be a principal to first-degree murder and conspiracy to commit first-degree murder. So principal is a person that was also a participant, that they did something to assist with, and knowledge of it is not enough. They had to do some sort of act in furtherance of and somehow be joined in the conspiracy, and their argument is that she lacked that intent. She didn't know anything about it, and there was no evidence of that. Then they lay out the preview of the trial issues, still on page 4. As the trial progressed, several evidentiary issues arose. In addition to that, the court considered motions for judgment of acquittal, which were ultimately denied. The court also ruled on the defense's motion for special jury instructions and the motion to disqualify the judge. And then below is a recitation, so they're going to go through and summarize the issues that the court addressed. 1. Evidence of co-defendants' abuse towards Miss Andrews. Now, the state attributed Miss Andrews' love for Mr. Chance as the reason for involvement in the murder plot. So because she's so in love with the co-defendant, that's why she was there. She's his ride or die. She's going to be there and help out in whatever way she can. The state presented Miss Andrews as a young woman who was madly in love with Mr. Chance and who would do anything for him. In reality, argues Andrews' attorney, Miss Andrews had no motive for wanting Mr. Jones dead, and her relationship with Mr. Chance was not as the state presented. The defense sought to establish the true nature of the relationship between Miss Andrews and Mr. Chance. Mr. Chance consistently abused Miss Andrews through the acts of violence, intimidation, and manipulation, and the defense sought to present specific incidents of this violence and to show that Miss Andrews' state of mind was during the relevant conspiratorial acts and time periods. So just prior to opening statements on October 26, 2025, Judge Sisko told the parties that the court would allow the defense to present the evidence of domestic violence, but it was limited. It could only come in through Alicia Andrews herself. Why is that a problem? Because, and they go on to say that there's an exclusion of defense witness. There was an exclusion of defense witness testimony. So Judge Sisko said that the domestic violence evidence could come in if Alicia Andrews herself talks about it. But the defense tried to call defense witnesses who could speak to their personal knowledge on the domestic violence relationship or the abusive relationship between Mr. Chance and Miss Andrews. Defense counsel argued that Miss Andrews' witnesses should be allowed to testify for two big reasons. First, to rebut the state's argument that Miss Andrews was not afraid of Mr. Chance. The state several times was kind of trying to make it seem like she wasn't afraid of him. Remember, they played some of the jail calls and how they're back and forth talking, and so clearly she's not afraid of him. Second, because the evidence was relevant and the court had no basis to limit relevant evidence to Miss Andrews' testimony. They're arguing it was relevant. It's relevant and they should be able to introduce it, and Judge Sisko said that testimony from Alicia's friends about the abuse that they witnessed, okay, this isn't just that they heard about, that they actually witnessed, Judge Sisko said was irrelevant, and because the friends didn't know what was in Alicia Andrews' state of mind on the day of the shooting, which I can see kind of arguments for and against there. It doesn't go to show what her state of mind was at the time, but if there is this long-standing history of abuse, then it might go to show what her reaction is or to explain away why she's present, why she is there. But I think the stronger argument might just be the issue about rebutting this whole notion that she's just doing it because she's so in love with him. The next one is a big one, the years-old text message. So do you guys remember this? During the trial, the state introduced messages between Alicia Andrews and a childhood friend from 2021, 3 years before the homicide. And those messages showed two girls discussing Mr. Jones, who was a well-known musician. In the text messages, the girls showed disdain for Mr. Jones. Miss Jones texted Miss Jordan, that's the other girl, who's Miss Jones? Miss Jones texted Miss Jordan. I think they got that mixed up. Anyways, Alicia Andrews texted the other girl, her friend, that she didn't like Mr. Jones, Fulio, that Mr. Jones was an ugly AB, and that Mr. Jones needed to die. The defense objected to the admission of these text messages, and the defense argued that the messages occurred long before the time period of this conspiracy, and they had nothing to do with the homicide conspiracy at all, making them irrelevant and prejudicial. And Judge Sisko believed that the text messages were relevant because they showed that Miss Andrews knew about Mr. Jones and the gang violence surrounding him. The defense argued that that's not an issue because Miss Andrews' knowledge of Mr. Jones had already been established by other evidence, and it was nevertheless overly prejudicial to admit the text messages, which had nothing to do with the present plot to kill Mr. Jones. They allowed that to come in, and the argument is that was not more probative than prejudicial. I guess the court said that that does go to prove something, and it's not overly prejudicial. The defense is saying that is way more prejudicial than it is going to show any proof of this conspiracy 3 years later. And I think that's fair. But I can also see that one from both sides. Now, the charge conference. Charge conference is when they go through the jury instructions to review what they're going to read to the jury so the jury knows the law and what they have to decide. So during the charge conference, Judge Sisko and the parties addressed the lesser included offense of manslaughter. She asked the defense whether it was seeking manslaughter under the intentional act. So manslaughter can be done where you do something intentionally, or culpable negligence, meaning I'm not doing it on purpose, but it was so negligent, so reckless, so disregarding any care or reasonable care that it rises to the level. So one has the intent and the other one not. The defense requested that they only be instructed on the intentional act, and Judge Sisko then asked the state what they wanted to do, and the state wanted them both in, of course. They want everything in to give the jury all these choices, which I don't know what the basis would be for the culpable negligence theory. Anyway, Judge Sisko included the culpable negligence theory in the manslaughter over the defense's objection. And so the defense, because of that, they asked it for a special jury instruction. The defense were allowed to ask the judge. The Florida Supreme Court creates the jury instructions. Every charge, almost every charge, especially the most common ones, obviously homicide, has a standard jury instruction. Manslaughter has a standard jury instruction. And absent any kind of big reason, generally we stick with the standard jury instruction. And however, we can can request the judge to give a special instruction. If maybe the standard instruction doesn't cover everything, or if there's something nuanced, something kind of different about our case, it fits the facts, it has to fit the facts. The evidence has to support what we're asking for in the special instruction, and it also has to aid the jury in their understanding, and it also has to be backed by the law. So it has to be a true statement of the law. And if it does meet that, then the judge should allow the requested instruction for the most part. So they're saying that they requested a special instruction about the principal theory. And principal theory, again, is how do they convict her of something when she's not actually the shooter? So mere presence at the scene, the fact that you're just present at the scene, including driving the perpetrator to and from the scene, is not sufficient to prove that the defendant intended to commit a crime. I don't know on that, because then we always have like those bank robbery cases and the person's in the car, the getaway driver. I guess the mere presence at the scene is not enough, but you would need some evidence that they intended to commit the crime or some knowledge of what was going on. The next one is a display of questionable behavior after the fact is not sufficient to prove that the defendant intended to commit the crime. Knowledge of the crime after it was committed is not sufficient to prove a conscious intent of the crime. So they want to be able to tell the jury, hey, just because maybe there was some questionable behavior after the fact, that's not enough to prove the crime was intended to be committed. And just because I might know about it after the fact doesn't prove I had an intent to commit it in advance. Don't put any case law there on that one, so I'm not sure how strong that one is, but I get the argument. So the state argued that the standard jury instruction was sufficient, which is usually what they argue when they're objecting to the special requested instruction. And the defense argued that she was entitled to it because, like I said, one, the special instruction was supported by the evidence. Two, the standard instruction did not adequately cover the theory of defense. And we, as a defense attorney, you're allowed or entitled to be able to present your theory of defense and also the law that applies to it. So they're saying that this standard instruction doesn't sufficiently cover their theory of the defense. And three, that the special instruction was a correct statement of the law. And again, remember, they did say that they were going to do supplemental briefing, so it may be that they'll later identify where in the law that specifically would be allowed. The defense cautioned Judge Sisko that if the court refused to give these special instructions, that it would be reversed on appeal. And the judge disagreed and said, hey, if there's a conviction, the second DCA will tell her otherwise. Judge Sisko did not provide a basis for her denial of the instruction. A lot of times judges will deny things and they don't give their reasons, which makes it really hard to appeal because it's hard to know if the reasoning was flawed or not. So that's going to be something that could be addressed on appeal and could be a big issue because of the lack of specificity as to why. And now we have a totally new judge, so that just creates another hot mess component to this. The motion to disqualify the judge, that on October 31st, 2026, they filed a motion to disqualify her, as we've already talked about. They reassert that there were various instances of clear bias, and the motion was denied by the prior judge. And then the verdict comes back, and the jury finds Miss Andrews guilty of the lesser included offense of manslaughter. And then finally, they talk about post-trial, meaning after the trial, the court set the sentencing for December 8th, and then, as we all know, motion for judgment of acquittal, or now we're bringing up, they actually filed it November 11th, which was within that 10-day window, but then the whole appeal thing happened. It stayed the proceedings, it stopped it, and then we come back and we get a new judge. So at this point, they're saying that their motion is timely, meaning they filed this under the appropriate deadline to actually ask this new judge to reopen the case altogether, to start over. Oh, another great question you guys brought up is, what does that mean? Is she now looking at life again if she starts over and has a new trial? The highest charges that she originally was facing, those are deemed acquitted. She's deemed not guilty of those, and you can never go back on a remand on a new trial and then the old charges don't get resurrected. So she would be coming in the gate with capped top charge that they could go forward on is manslaughter to begin with, which then that's going to be difficult for the state to prove, because I'm not sure that there is any evidence of manslaughter, but I guess they can make the argument. Anyway, the rest of this is just a memorandum of law where then they lay out the rules regarding a motion for judgment of acquittal and when the court can grant a new trial and the reasons for it, and then why they believe that the judge erred. This part mirrors everything they filed in their original motion back before we were set for sentencing. Shortly after the verdict, they filed this, and there they get into some other things that we hadn't talked about. Verdict is contrary to the law. We've already talked, the manslaughter just doesn't make sense. The other thing they talk about is that the court erred by not giving the proper defense instructions. So that was already laid out at the beginning. But a different reason was they had this issue with the jurors. When they were questioning some of the jurors, apparently there was a juror that was some sort of political person, and they're a tough on crime individual, and because of that they asked for a cause challenge, meaning they wanted to strike the person for cause, that this person can't be fair and impartial because it's clear they have this line of work, they've always taken this position of being tough on crime, and so we don't think that they can be fair in this case. And the judge denied that request, and so they had to use one of their peremptory strikes. In these cases you get 10 peremptory strikes, meaning I get 10 chances to just knock someone off, and as long as it's not like a discriminatory reason, I can choose anything. I don't feel comfortable with how they dress or how they were looking at my client, or I can use any of those peremptory strikes for those reasons, or maybe the type of job they have, I think that they may not be unfair. But a cause challenge is where I say I get to strike them for free. I don't have to use one of my 10 for striking them if they say, oh, I'm always going to believe a police officer over anybody else just because they're a police officer, or if they say, oh, maybe for religious reasons, I don't think anyone should be judging someone else, or anything where they just can't do it, or I had a death in my family, someone was murdered in my family, and I could never be fair on this kind of case. So those people get stricken for cause. So this one, they're arguing that they believe they had enough to strike this juror for cause. The judge said no. They had to use one of their strikes, and then when you end up using all your strikes, you get to ask the judge, could I have an extra one, because we believe we were denied a cause challenge, the free one, and we had to use one of our 10, and the judge denied that request. But in order for them to appeal that, they had to do that to preserve the issue. So anyways, that was another one of the issues. And then the last point was basically she was denied a fair trial, that there was bias based on the judge. You've seen that she was removed by the second DCA, the appellate court, and so we believe that she didn't get a fair trial, and we're asking this judge, the new judge, to allow her to have a new trial with a new jury and basically start this over again. So that's it. I know it was long, but I really wanted to get back with you guys on what was going on with this. There's a lot that the judge has to review. This will likely then be set for hearing to determine whether or not the judge is going. Usually it's not necessarily something that they're going to argue in court about. The judge might just take it under advisement, review it, and make a decision without having a hearing, or she may allow the parties to make argument. I don't know, but we shall see. There is a hearing set on the 10th of March, and maybe they'll lay out some sort of timeline for these next steps. But either way, they only recently requested the transcript, so that's going to take a bit, and the new judge has to review everything so then she can make a fair decision on what Alicia Andrews' attorney is asking for now. As always, thanks so much for watching. Appreciate all the comments and questions. Keep them coming, and we'll be back with some more updates soon. Take care.